without a way to move forward. In other words, for them, I think it sometimes creates mistrust about what we are all really doing here and how we can support or not. But also it might leave them with an impression that the person's just going to continue to get away with it, which is, one of the concerns that a lot of survivors have. So I wanted to make sure that we talked about that. Um, and then also that they can be provided information about the curriculum that's used at your agency. That is always helpful information to share with survivors about what kinds of discussions are happening, the tools that are used in the curriculum, what they're helpful for, what the core messages of the curriculum are. Those are things that are helpful because on the other side, we've had many examples over the years where survivors come and say, my partner told me that their group facilitator said women are just as abusive as men. Women need help too. Women need to learn this or that. Or they said I don't belong in group, really, that I'm not that abusive. I mean, there's a whole range of things that partners say to the people they've hurt that are just the same kinds of manipulation tactics, coercion, punishing kinds of things that often are the reason victims will contact an agency and say, what is going on over there? What are you all talking about? So that's the reason I think a thorough review of the curriculum is helpful. Uh,
Anna,
yeah.
what would you suggest if the victim wants to do counseling, contacts them and wants to do counseling or seems to be in distress? Because I know we had discussions with one agency that I, DHS doesn't even allow you to treat people in the same building, right?
Well, yeah, I mean yeah, that's a risk, right? That's why we don't do that. But also, I mean, my thought would always be to um encourage them to touch in with an advocate who might be able to provide resources in the community for tailored experiences for survivors. Places that we trust for them to access therapy, things like that. But and I think we all know the piece around couples therapy and that that's not something we provide as a part of this process and the reasons why. But I think the way that I would maybe in the moment redirect that is say, there are advocates who can talk through all of that with you and what might be the most helpful kind of support, because sometimes they might be asking for therapy because their partner told them they need help too. And that might be a way that they can get back together, but it's really not. That was a tactic. And so I think the good news about the advocates is that it affords people the space to talk through all the different thoughts they have and feelings to make sense of it and decide what's their priority in that moment and what do they really need. Sometimes it's not always clear. Okay.
Anna, Anna,
Yes.
I just have a quick question.
Yeah.
You mentioned our consent forms that we do, and we do one that's confidentiality and limits to confidentiality. Are you saying that are you still asking that we now include that the victim may receive information from us?
Judge, I'm going to let you answer that based on your research that you did after the last meeting.
Yeah, I think that some of the agencies said they had a separate form for the victim confidentiality, and I wasn't sure why they had that, but I definitely think that part of the intake form should include a waiver of confidentiality and just along the list say the person who, the victim or however we want to call it, the survivor should be on that list of some of your information may be shared. And I know that MEP does it, right? And so what we've also done based on those meetings with me and Amanda is you guys sent us all your intake forms, and we've got April is working on getting them all together. And so what I'd like to do is send out some like best practice intake, forms based on what you guys have, based on what Emerge has. And yes, I want that incorporated into the fact that you can, that he has to waive that privacy as far as with the victim also. And like Anna said, I don't think it has to be the whole case file. It doesn't have to be, but it has to be the public information that you would be giving the court, basically, is as far as we want to.
And it may be helpful in that is a part of that piece of the consent to include language about, just what I said in terms of like DV intervention groups are different because there are other people that are impacted by what has occurred and what landed the person in group, but everything they do in group will continue to impact the people that they harm. And so it may be a statement about that. But you could also include some of these bullet points here about what kinds of things would be shared with the victim if they reached out, like information about the curriculum, group processes, those kinds of things, so that it's clear that it isn't, the progress notes of their participation in group getting shared, but that victims have a right to ask questions about this process, because the process is intended to be accountable to them, right? And the experience they have had of harm. So it's more along those lines, and that might help to explain that part of the consent, so that it doesn't feel like it's, oh no, they can call up and read my chart, or, those kinds of things. So hopefully that helps.
And I think that actually would maybe lead to a little more participation and stuff because, or less, because to know that if the victim's interested, that they can ask. I think that that's useful. And then also I think it's useful the victims come to court sometimes and for them to hear what they've received as part of that information is useful.
Right. And the other thing I want to say, and this is not anywhere in this document, but just, for just like consideration that, we all know that many survivors and partners of people in groups, they're making decisions about whether they want to maintain that relationship, return to the relationship, how they want to co-parent, if that's a factor. And so I think how we can afford access to this process for survivors and partners helps with those decision-making points for them as well. Otherwise, they're at the mercy of what their partner or ex-partner is telling them, which we all know what, the range of things that can look like. Okay, so the next section, I'm on sharing information received from a victim. And the biggest piece there is to not assume that it's okay to share it. Always, always, always ask for permission to share the information. And then a real specific question around, do you want the person in group to know that you shared this information? Because that will really dictate what steps you take after that. And if they're not sure, if they're fearful of that, the best move is to say, let me connect you with an advocate, because the advocate is fully confidential. They can work with you on your options for sharing this. If it's something you want to do, I'm not best suited to do that. I have a real specific role in this group. So I think if they're not sure, or they're afraid, get them to the advocate and the advocate can help them. Just as a thing to know, probation officers often have information about people on probation that victims do not want them to divulge. So it also is okay to say, is it okay with you if I tell the probation officer, and I will make sure that the probation officer understands this is not to be shared, and then make sure that you're following through on that, and that we don't have a snag where something gets told to a defendant that shouldn't have been. Okay, so then referring the victim to Emerge, and I'm looking at an outdated version, but I know what it's supposed to say. So this section is, there are generally speaking, 3 times you want to consider making a referral. And now the referral form, we revised it to be about high risk indicators. It's not, everyone gets a referral. I mean, certainly if someone asks, please do. But for the most part, we're thinking about risk level, and we're thinking about changes in risk level or what might appear to be a change in risk level. And so at intake, if it seems like it's a high risk situation, if you're picking up that the person coming into your program maybe is still abusing, being volatile by way of the things they're saying, maybe they're being dismissive, there's some real overt victim blaming. And when you look at the details of the case, it was high risk. That's a great referral to make because it's likely the probability is high that they may still be engaging with the person they harmed in a way that's abusive and harmful. The second time that you want to think about a referral, or counselors want to think about it, is if in the process of group, the person seems to be not developing any new awareness, right? And they're beyond 12 weeks of group. They've been in long enough that if they were going to change, you might expect to start see indications of that. Or they're starting to say things that make you think it's going the opposite direction. That is when you want to bust out the BIRM risk management worksheet. You want to start thinking about that worksheet, and that's when we're going to start thinking about maybe staffing the case. And you want to make a referral to the advocate so they can engage with the partner or the survivor in that situation, potentially in preparation for a staffing. And then the third time you want to make a referral is if in the course of group or engaging with people who are in your programs, you hear things that sound like they're violating court orders, probation conditions, orders of protection, those kinds of things. Like if you know they have an order of protection against them and they slip in group and say they were chatting with the person the other day, that's an indication that you probably should do a referral. And then the role of the advocates is going to be to work with that survivor or partner to make a decision about whether they want to report those violations. And then the process to do that will support them through that if that's something that they want to follow through with. Let me pause there before I move on to staffing. Is there any questions about that?
And we included that form that you can use. And does it have an email on it, Anna? Does it have a place for them to send it on
The
it?
form, which form?
The referral form.
Yeah, the referral form at the bottom has the email address you can send it to, and there's a fax number if anybody still faxes things in this world. I don't know if that's still a thing.
And
Someone told me yesterday to stop saying PowerPoint slides and that it's now called the deck.
oh
And I
yeah.
was, oh, okay, noted. So I don't know. But we do have a fax machine. If you still fax and would like to fax the paper to us, you can do that. Otherwise, you can email it to that address. And the form is pretty, let me pause and move to the referral form before I go to staffing, if that's okay. So let's look at the victim referral form that was in the packet the judge emailed. The more information you can fill out on the form, the better it is, the easier it is for us to follow up. So another thing to maybe consider about intake is making sure you have a place where you're collecting information about the survivor, their name, the language that they speak, do they have a phone number, those kinds of things are helpful. The form asks you questions about their preferred language, but also whether it's safe to leave a message at the number. You may or may not know that. So if you don't know that, you can check no or unknown, and then we'll proceed with caution until we can figure out the answer to that. The other question on there that's really helpful is, has the victim been notified of the referral to emerge? That helps us to then just know how to start out the call and explain who we are and why we're calling, if we know whether you've had a conversation or not with the victim. And then the next section is just information about the relationship and children, and then whatever information you have about court orders, pending court cases, those kinds of things. Um, and then, so there's a difference in the potentially the victim abuser relationship. That's the victim survivor contact information, I'm sorry, is the person that was the listed victim in the case. And so that's the important thing, like the person they harmed that landed them in your group. A little further down under the court information section, you'll see a little box there that says current intimate partner information. If there is a request to have an advocate contact a current partner who is not a listed victim in the criminal case. That's a really important thing I wanted to point out, because often people are not continuing to engage with the listed victim in a case, but they have a new partner. And you might hear things in the course of the group process that indicate that person might be in an unsafe situation, or it might be helpful for someone to reach out to them. And I wanted you to know you can put that in here, and we will contact that person and explain who we are, why we're calling, you know, that sort of thing. And we'll approach that conversation knowing they are not the listed victim in the case, but a current partner.
Anna, can you,
Yes.
two things. One, I don't know if everyone knows that adult probation requires their probationers to tell them when they have a new partner, and then the new partner has to come in and sign a waiver and be told about all the things the person did to get them on probation. But the second thing is, what always struck me is that I know you guys don't like cold call, like when you're like, oh, I'm worried about this person, will you call them? But you do it a different way when people are in treatment, right? And I think that bears repeating, like how the advocate reaches out to the victim in these
If
situations.
if it's in what kind of scenario?
Like
Cold, like,
if they're referred, right? So if the treatment providers are concerned about what the defendant's doing in group, sends you this referral, how come you get to cold call this victim? For example, if the treatment provider hasn't talked to the victim, right? Because you don't usually call people who don't want to talk to you, right?
oh, I see what you're saying. And I can ask Jessica to jump in here and maybe speak to like how those conversations go and how we set it up. But generally, it's this part of our system. I would think of it like this, that it's part of the process when someone is engaged in a change process, and that the perspective and input of their partner or the person that they've harmed is really critical for y'all to know whether you're working on the things that really matter, whether the information they've shared with you is the truth from their partner's perspective. You know, it gives us a lot of really rich information, to be honest, but it really is about making sure that the work we're doing in groups to facilitate change is focused properly, that we're prioritizing the things. You know, they may come in and say, well, the biggest thing I have a problem with is raising my voice. When it's from their partner's perspective, it's that they destroy all their property every time they get mad, right? And if the person in group doesn't share that and you didn't have that information in any kind of collateral source, you wouldn't know that. So that's why, and that's how we explain it. Jessica, is there anything you want to add to that particular piece and how we do those nuanced situations?
Sure. I will say that in the circumstances where we're reaching out to like new partners, similar to when they're coming to court right? And the judge is like, "Are you so and so? Oh, you could always talk to the advocate too." It's we really piggyback off of the court system and the legal system and saying like this is part of the process, and so we just wanted you to know that we're available to support you as well if you had any questions or concerns. We're really just trying to open that door in case there is something they want to share or in case something happens in the future. We want to let them know this isn't just about focusing on like a one-time thing that happened with another person that happened to make it into the legal system. And we do share a little bit more about like how, again, the goal is for positive change and for that to spread throughout, beyond court once court is out of the picture. So we really do just kind of lean back and say it's more about like a part of the whole process, and that we just wanted to make sure they're included in it because they're now involved with this person. This is going to affect them just as much as anyone else. And so we try to make more of just like we can be a resource for you if you need it. And I feel like in the past when we've done that, at some point, like it's worked. They've reached out. Like it might start small, it might be like a little question here and there. And but yeah, it's just opening that door to them.
And know that sometimes initially they're like, no, I'm good. Everything's great. They're wonderful. They've not done anything to me. Fast forward 4, 5, 6 months. We all know that if someone isn't really working at changing, the likelihood that those behaviors are going to show up again is really high. So, them knowing that there are advocates they can reach out to and how to get to them is really helpful. So, Erica, were you going to say something?
It was. So you said that, are you guys then gonna share some of the info with us group facilitators so we know how to incorporate it? Or
Yeah. So it will depend on we will the survivor partner that question. We'll say, do you want us to share this information back with the agency? If so, how? What do you want shared? And those kinds of things. And if they say yes, then we will reach back out and share it. And then I think, and this is something that I love to see in the protocols, if y'all don't have it somewhere else, is just a reminder for facilitators that under no circumstance should they ever say that they obtained information from a victim, that it should just be incorporated into how they're working with that person and making sure they're paying particular focus. But I cannot stress enough that reminder. But that's the language that we use with partners. And then the other thing that we have discussed on and off is whether we wanted to bring back that, I think it was called the tactics report, which was the summary of all the things survivors are sharing with us about their experiences while their partner is in group, but that they didn't want us to share back in an identified way. We can compile that into a report and just give general themes so that in my head, it's not about a criticism or critique of the agencies, but just things to know that this is how it's playing out at home. And we all often think it's one way. And then even though we logically know we don't know everything, I think sometimes we forget that we could be totally taken on a ride by somebody and have no idea what they're doing at home because they're showing up in group in a way that makes us think they're changing, they're getting it, they're working hard at it, all to find out they've continued their behavior. So that tactics report is sometimes helpful with centering us in, just always be mindful of those things. Okay, so then on the referral form, then there are just the high risk criteria. As a reminder, this criteria is the same criteria that the city court prosecutor's office uses to decide which cases they're going to refer to Yasmin, who is the high risk advocate at court. It's also, they're also in alignment with some of the pieces from appraise and just sort of general risk, the things that have the highest correlation to risk. And then we have under the additional comments, I wanted to talk about this because sometimes there are other factors. Sometimes they are life factors, like other legal issues, things going on in their life that might exacerbate risk, but aren't by themselves like a standalone risk indicator. So that's things often related to people's identities or ability to access help and support, like race, gender, sexuality, ability, immigration status, those kinds of things. If you feel like it's pertinent, that's always helpful for us to know. And that might be the reason it becomes high risk. Maybe you're not checking too many of those boxes just above it, but if you check one of those boxes like gun use, and then you also know that the survivor is maybe doesn't have a lot of mobility because they can't walk, they use a wheelchair, like those kinds of things, that exacerbates risk in a different way. So that's what that section is for.
Um,
um,
can I just point out too, I think that what we see a lot in probation reviews, and I know that you guys are all familiar with it, is the abusers losing status, like job, housing, substance abuse. So to me, that's part of this too, that we should be identifying them, because when they start to like lose hope and become depressed, that's when I start to worry about them. And we can also, when we see those kind of things, bring in, victim or bring in defense attorneys and everything. So obviously it's going to go to the staffing, but I don't think we should forget it as that being also a high risk thing if that defendant's kind of falling apart, basically.
Absolutely. Thank you, Judge. So then the last little section on the referral form is please, and this is where like filling this form out in its entirety or as best you can is really helpful. Obviously the agency, the facilitator name, when they're in group, if you know who the probation officer is. Sometimes if it's tricky to get in touch with the survivor or partner, we'll call when we know their partner is in group. So that's why having that information is really helpful, because sometimes it increases the likelihood that we'll make contact with the survivor if they're not worried about their partner being around. And then lastly, we put this on here, and I'm not sure how feasible or realistic it is, but if you have any collateral information that you can share with us, that is helpful to the advocates to understand the full picture of what has gone on, and then it helps us to not ask questions that make people repeat things. And what the advocates do is say, oh, as a part of this process, we have access to the police reports or the this or the that, and I read that. So that I also don't want to create an impression for survivors that we're like talking about them and sharing their information in a way that's irresponsible, or those kinds of things. So we make sure that we explain where we obtain the information, and that, and then we'll ask, is that accurate? Is there more you want to say? Those kinds of things. So that's the last piece on the actual referral form. So then if I go back to the document that's the like guidelines, the very last section there is requesting a case staffing. So this is a new process that we're trying. When you have a concern about safety, compliance, fit in a program, not sure they might need other services first, etc. Or risk seems to be changing, it's escalating. We're asking that you request a staffing, and when you request the staffing, you will have filled out the risk management worksheet, the BIRM one, that the judge sent you, because it just gives a little information to the judge about what's going on, what you've tried, what your thoughts are to prepare for the staffing, and then it helps to know who needs to be in the staffing as well. Judge, is there anything you want to add about that staffing process?
Yeah, we run into this. I think we have to be careful to pay attention to so the first thing is, to me, none of this staffing is about revoking probation, because as soon as we start to revoke probation, then I have to share everything, right? But every now and then we'll do a staffing where there's already a defense attorney on there. So we have to be careful to know the status of the case. And who might be invited to that staffing. And, my minute entries will usually have a defense attorney name on there. If it's on probation, you guys get our minute entries. But if you have a question, you can always ask Amanda or Federico, is there a petition to revoke pending? Because if there is, then everything has to be shared with the defendant and the defense attorney. If there's no PTR, then to me, I don't have to share it with anybody, and we can decide who to bring to the staffing and what we're going to talk about. Because to me, we're trying to keep the victim safe and get the offender in a place where they can be successful. We're not like looking for violations of probation. So that's why I think I can participate. I don't need my lawyers there. Like yesterday, I did a staffing with Jason and Marcos, and I asked the prosecutor to be there, but I didn't need a defense attorney because there's nothing pending. And I said, we're not trying to revoke him. We just want to know, is he like going to be successful in Marcos's group? We had, probation. We invited the advocates, but the victim in this case is in DOC, so they haven't had any contact with her. But that was part of my question: is like, okay, the victim's not around. What's he saying that's true? What's he saying that's not true? So it's really dependent on the case, but just be careful before you send me anything that you've checked with Amanda to make sure there's not a defense attorney. And if there is, and you still want to request a staffing, that's great, but they're going to be there. We've also discovered that a lot of times we want to bring in the defense attorney because they can add some compliance and talk to their clients. Like we did one the other day where the victim and the defendant wanted to do couples counseling at their church. And it was really helpful to have the defense attorney in that staffing. And then he went back and told his client, I know you want to do this, but you really need to do your DV stuff first. And the advocates were talking to the victim. And so it wasn't about violating them. It was like, okay, how do we keep the victim safe? Because she's trying to do something that we don't think is safe at this point, basically. So if that makes sense, if you're in doubt, and you don't put something in that you think I might have to disclose, and then we can go from there. The other thing I think that Jason had a point last time, which was, okay, so sometimes we learn stuff that the victim has told us, but we won't want the defendant obviously to know that. And so you can address it in group as a tactic that you talk about with the group when we've learned something that the defendant's doing. So I think that's a really helpful way to handle those two.
That is all of the things we had. Are there any additional questions, concerns that folks want to talk about with the few minutes we have left?
Do you have a sample protocol that MEP uses? Do you guys have one? Like for the victim contact?
I don't know. Javi, did we have that? I mean, we have some stuff in the helpline manual, but I think it's in writing in a protocol somewhere. I have to locate it, Judge. It's somewhere in all our stuff.
I'm
We
just
have all
saying.
kinds of things like scripts that we use, handouts. I mean, there's all kinds of things documented. So,
All right, well, you're on my list, so I would like yours. But what I would like is yours so that we can share it with
yeah,
everybody so that
absolutely.
they have like a best practices
Yes.
kind of protocol that they can base theirs on. And so, we don't and I guess my other question would be is I want the facilitators to be aware of this, not just the agency heads who are here now. And I think that was, and I don't believe any of you were there, so I'm not trying to slam anyone here in the room, or anyone, but I think that was the problem with the collaboration last time, was it wasn't clear that everything being talked about at the collaboration with probation and everything was getting fed down to the facilitators. And honestly, I like only started recording this halfway through because I thought I hit the button and I didn't. So I don't know how useful this will be, but we would love to do this again with all the facilitators. So you guys go back to your agencies and talk to us, talk to them. Let us know if you think it's something that we can talk to individual facilitators about. Do this again at a time that would work for them. Right, Anna? We can do this as many times as you guys
Yep.
need.
Yep.
It needs to be disseminated to everybody. So,
And then the last thing, the last time we met, and I don't know how many of you still have this, but the judge handed out the BIRM risk assessment factors. And that was provided to help everyone take a look at your risk assessment that you're doing at intake and just to make sure that it's covering all of the indicators that are listed there in some kind of way. That way we're making sure we have thorough risk assessment and collecting of information.
What was my question, Anna? Do you guys have one that already incorporates it, or because I'm working on incorporating it, but it's not going very well. So I was wondering if you had any examples or any assistance on that.
Yeah, I mean, well, we have the one we use in our program, which is basically a long list of, discussion points about all of these risk factors. So we can put together a packet of what we use and then send it out. I know that in initially looking at what April compiled, I think there was only one agency that really had a really thorough risk assessment as a part of the intake. The rest was much more like standard intake, psychosocial, demographics kinds of things, like social history kinds of things. Those were really thorough, but the actual risk factors for domestic violence were not necessarily a part of it. So that's why I think the judge was saying let's create a sample one, but I think probably ours in MEP is going to be the most comprehensive as it relates to the risk factors, so we can send that out.
Yeah, I think it would be great to have people using the same kind of thing. Obviously, you're going to do all your other intakes that you're required to do by your agency, but if we can have that incorporated. Oh, can I just say one thing? So I talk to everybody, I think, and it is my understanding that when you staff your agency staff with me, staff with probation, there is a method that you have, and it's different between agencies. You can sometimes people just say staffed. Sometimes people have a separate file that isn't in the defendant's file. But to me, it's extremely important that we're all on the same page that that can't be in a file that the defendant can access. Things that you've talked about in staffings, things that you've talked about with probation, information you be getting from victims. But I know that the agencies I've talked to, I don't think I talked to Jason or Deborah about this, but I know they've been doing this a long time and that they have a method for doing that. But that was a sticking point, and it's a huge one. And so we cannot have that information from the staffings and the conversations we have be in the defendant's files because it's such a victim safety risk. And so like I said, I talked to Kama, talked to Erica. I just want to make sure that everyone's on the same page, that that will get you off the list and you understand that, that we need to know that some of this stuff is staying confidential because we don't want anything that we all know from the victims to be shared with the defendants. So.
Yeah, and emerge like in our little system, we have progress notes and then we have something called staff notes, which staff notes are not released with the file because they're not content that is specific to that person's progress with us or services we're providing. It's sort of like either internal communication stuff or things that are just completely like unrelated that somebody wanted to note, but it's not pertinent to their process with us. So we manage information in that way as well.
All right. Anybody have any questions or any concerns? And we'll send you stuff out because I think it's a hard ask to say, okay, recreate all your documents. We don't want you to do that. We will get samples to you. That's why we collected everything because I wanted to see the best of everything. So,
and I will send out that partner's guide too, so that folks have it in case it's helpful language. And anything we send out, you're welcome to copy and paste and edit language to make it fit for your agency if that's easy.
And I'll send out this partial recording for you to share with her. So, but thank you all for your time. I really appreciate it. We'll keep, and you know what? My biggest thing is that with Amanda gone and Federico taking over, we may have gaps in the list we send things out to. So look at the email list when I send stuff. And if your facilitator's not on there, let me and Federico know. And we're going to try to have a more updated list. But I think that we have some issues because Amanda's not here, won't be back until the end of January. So, but thank you guys. Take care.
Yes, thank you all. Have a good
Thank
weekend.
you. Apologies for me being late today.
You're good.